can. Online at letstalkfaith.com. The following program is sponsored by the law offices of Patrick L. Smith. This is the Attorney Patrick Smith Show. Get ready with your legal questions and call Patrick now. 877-943-9673. Again, that's 877-943-9673. The law office is open. And now your host, Patrick Smith.
Oh, hi there, and welcome to the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith, and we are live and in studio. We will be with you for the next hour. It is Saturday, January 22nd, and we will be here to answer your legal questions. The whole gang is here in studio. We've got Peter the intern in studio with us, Yana, the Belarusian producer, and Brian, the call screener. And we'll be answering your calls and getting you lined up and queued up to ask yours truly your legal question today. To do so, you simply call in 877-943-9673, 877-943-9673. I'm your local attorney, Patrick Smith, here to answer your legal questions for the next hour. Any way we can help you, your opportunity is now. You can call in and we'll be happy to give you the very best legal advice we can live over the air on a rainy Saturday morning, although my mother always called it liquid sunshine. So mom was always an optimist, a half glass full kind of person. So liquid sunshine outside this morning. 877-943-9673. That's your live and local number to be part of our show today. 877-943-9673. And you can email your questions. Peter the intern will read them live on the air. You can email them to Patrick at attorneypatricksmith.com. Patrick at attorneypatricksmith.com. All right, let's go to Newport Richey and let's talk to John. John, welcome to the Attorney Patrick Smith Show.
Yes, good morning. I have a question for you, please.
Go ahead.
Can you please explain what happens when the grantor of a trust dies, and what happens if the assets have increased in value?
So your question, John, just to make sure I'm understanding it, is what happens in general, number one, when a grantor of a trust enters eternity, and number two, what happens to those assets? Is that correct?
What happens to the assets, in particular, if they've increased in value, if they might be stocks or bonds and they've increased in value?
Fantastic. Yeah, fantastic questions to start the show, John. So let's take them in turn. Number one, when a grantor of a trust passes away, typically, and granted each trust is governed by its own terms, but in general, when a grantor passes away, that trust, which was typically revocable, becomes irrevocable, meaning it locks in. All the terms and conditions are immediately solidified for forever. They cannot be altered without any sort of judicial modification, okay? The successor trustee takes over for the deceased grantor, who is typically operating as the current trustee of that trust. And they take over, and they basically serve as a de facto, what they call in other states, executor of the will or personal representative of the will in Florida. But if you're a regular listener to the show, John, you know the difference here with the trustee of the trust. You don't have to go through probate. So you can serve as the trustee with the death certificate. You would reach out to a very good and qualified tax professional. We typically recommend CPAs who will help you get the tax ID number for the trust accounts, because the previous accounts were under the deceased grantor's social. Well, you can't really do any business under a deceased person's social. So you would go and update all the information on these accounts so that the account reflected the grantor's passing, the new trustee accepting that appointment as a successor trustee, and they would start doing what we call marshaling the assets. They would pay creditors, and then now leaning towards your second question, they would settle any tax obligations. So that's where you'd have to go through asset by asset and ask yourself, is this particular asset within the trust going to receive what we call basis adjustment? So under the current tax code, there's a provision that gives you an adjustment to date of death value for highly appreciated assets, but it doesn't apply to all assets. Some are carved out from this, and this is really where the accountant proves helpful. They'll walk you through which of those receives that basis adjustment, which ones do not, and then you can determine what, if any, capital gains is going to be triggered if a particular item is sold or liquidated. So you would kind of have to take it in turn, asset by asset. Is it a cash account? Is it a piece of real estate? Is it a qualified account? And walk through with that sort of particularity so that you can assess the post-mortem optimized strategy to reduce or eliminate those taxes.
So the trustee has to appoint a tax advisor then?
I don't know that they have to. There's nothing in the code that I'm aware of that says they're required to, but here's why they typically do. And I serve as trustee for many clients. And I'll tell you, the reason why I always bring in a tax professional is because if I'm agreeing to serve as that person's representative, I'm accepting personal liability, John, for their taxes. So I want to make sure that not only have we settled any tax debt for the sake of the beneficiaries who are going to be getting this money, it's to protect me as well, because I want to make sure that I'm not left on the hook. And we typically order something called a 4506T. That's a transcript request for the last 3 years' returns. That's the statute of limitations. And we audit to make certain that all the taxes that were due have been filed. But here's the other thing we audit for, John. People say to me all the time, they say, well, my deceased loved one never filed returns. They didn't make enough to file a return. All the more reason to check this audit, because one of the newest avant-garde identity theft strategies is to steal the identity of elderly who do not file tax returns, or even if they do, they're filing amended returns behind their backs. And these amended returns can go undiscovered. Well, if you're the trustee of the trust and this return goes undiscovered, at the end of the day, that gets wrapped around your neck as the trustee. So you want to make sure you've assessed that, addressed it with the IRS, reported it as fraud, and get that investigation initiated and concluded so that everything can be administered without any hiccups on the back end after the money's been distributed to the beneficiaries. So I don't think you have to hire a tax professional, John, but I strongly recommend it.
But if you do, how does that accountant get paid?
Typically, they get paid from the trust corpus. So in that final accounting, because all trustees, there's a mandatory duty to account to your beneficiaries unless it's specifically waived by your beneficiaries. And in that accounting, you lay out not only the trustees' fees, any attorney's fees, you lay out out-of-pocket expenses, the fee to pay for the funeral, the fee to pay for final credit card bills, things of that nature. You lay all that out, and then you serve it on the beneficiaries, and they have 30 days to review that, question it, object to it, sit down with their own separate counsel, do anything they'd like. So there's an ample opportunity for them to review these facts and figures, ask questions, get clarification on any of those expenditures, and then ultimately sign off on everything and receive their distribution.
All right. Thank you for that information.
You're welcome, John. Thanks for calling in. Enjoy this beautiful rainy Saturday.
I'll try to.
All right. Thank you, John. All right. You're listening to the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith. 877-943-9673. 877-943-9673. Live and local open phone lines. We'll get you right on the air just like John did. And great question to start the show. Really got to run the gambit there with trust and trust administration and some of the post-mortem artistry that trustees practice in optimizing their beneficiaries' best interest by retaining an appropriate tax professional to make certain that the money is free and clear of all claims when that money is handed over to the beneficiaries. So absolutely fantastic question to start the show, John. Thank you for that. 877-943-9673 or email your questions to patrick@attorneypatricksmith.com, patrick@attorneypatricksmith.com, or give us a call. Talk to us on the air, 877-943-9673. All right, let's go to Peter, the intern, for our first email question of the day. Peter, you're up.
So the first email question of today says, my mother recently passed away of breast cancer. She did not have a trust or a will done, and there are many bills that are still unpaid. What can I expect in this probate process?
Oh, I'm sorry about your mom. That's awful. Losing a mom, I can only imagine what that's like. That's got to be terrible. So we'll say a special prayer for you regardless. As far as what you can expect, with no will, it's going to go by statute. So if mom was not married and left children, odds are it's going to go to those children. If you're the only child, it would go to you. You would need to retain counsel to petition to open the probate to unlock any assets. If there's simply debt and no assets, it's a bankrupt estate. It may not be worth exploring. If there are assets, You petition the court, you get appointed as an administrator, personal representative is our term in Florida, and then within 60 days of being appointed through your counsel, you'll report back to the court on those assets through something called an inventory. And concurrent running with that 60-day window is something called a notice to creditors. That's how we're going to address these creditors. The creditors we know about will notice them directly, and that shifts the burden on them to file a claim with the court. If they don't file that claim, then we don't have to pay them. If you receive a claim from a creditor that you believe is not a valid creditor claim, then all you simply do is object to the claim through your attorney, and that'll shift the burden back to them yet again, letting them know they have 30 days to either file an independent action or walk away. And if they don't file that independent action, they walk away unpaid, obviously, at that point. And at the end of the 90 days, you then assess all your valid creditors. There's a 1 through 8 hierarchy under our code, so you would assess all your creditors and pay them according to class 1s first, class 2s, 3s, 4s, all the way down to 8. And if you ever get to a class that you cannot fully satisfy, you would do a pro rata distribution among that class, prepare a formal accounting, serve it on the outstanding creditors to explain to them why they're not getting paid and the estate is bankrupt. But let's assume there is money to pay all the creditors. You get beyond that. You've paid the creditors. Now you're in that tax phase that we were just talking about with John. You're going to make sure that you finalize the decedent's final tax return, filed any 1040 that's necessary, any 1041 or the 706, which is pretty rare nowadays, considering the estate has to be over $12 million for that to be necessary in most cases. But at the end of the day, you would simply satisfy those creditors, prepare the accounting after you've finalized the tax return, and then you would carry out the distribution. With what's left over, you would distribute it as an inheritance. But that's the probate process. In a nutshell, we do complimentary consultations on probate because that is a lot to sort of drink in on a Saturday morning. So I'll give out the office phone number here in a little bit if you want to schedule time to come in. And in the privacy of the office, we can sort of go over the details. If you're out there dealing with a probate situation and you just want to find out more about that process or where you are in the process or how to move it along a little faster in the process, we'll be happy to help any way we can. Great email question. 877-943-9673. And again, so sorry about your mom. That's terrible. 877-943-9673 or email your question, patrick@attorneypatricksmith.com. All right, let's go to St. Pete. Let's talk to Sue. Sue, welcome to the Attorney Patrick Smith Show.
Good morning.
Good
My
morning,
question
Sue.
is a rental question.
A rental question. Great.
Okay, well, a friend of mine who is a senior citizen has been renting from her landlords for decades. And she got a phone call this week saying, by the way, we're selling all of our rental properties and you have 60 days to leave. So this is problematic. I'm wondering, is there any sort of rental moratorium that may apply for her to have more time, to address the situation? It's going to be a very difficult one for her.
Yeah, and I think you're alluding to the CDC's moratorium. Go ahead.
Yeah, I mean, I'm not sure. I don't follow it because I had no reason to, but there's no written contract. It's all been verbal. But as I said, she was told she has a 99-year lease. She has moved from property to property to accommodate her landlords as they run their rental business. And so all of a sudden, you're no longer a family friend, and you have 60 days.
Wow, that's terrible. The short version is I'm not aware of any moratorium currently in effect in the state of Florida. So I don't think we could really position ourselves there. Where I would want to sort of position myself and hunker down on behalf of this elderly person is within the terms of a lease. So even if it's a 99-year proprietary lease, there's going to be some sort of written instrument. Now, if you're telling me that there's no 99-year proprietary lease, there's no tenancy for years or tenancy for months or any sort of lease document, it is strictly oral. It's a handshake deal.
Right.
Then everything defaults to the statute. And the tenant, in this case, would have very minimal rights. I believe under the code that it's 30 days that they have to give them notice. So the fact that they're giving them 60 days notice would be generous in terms of what they're entitled to. And,
Okay.
and I think that, did they pay anything additional for the 99-year proprietary lease? Like, was there a lump sum payment early on when
No.
this began? So it really has
No.
been just a straight lease, month-to-month handshake deal for all these years.
Right.
Yeah, I was hoping that there would have been some kind of big payment. So, like, if they're paying $500 a month, that first year they maybe paid $2,500 the first month as like a buy-in, and you could sort of say, look, we've got evidence that the course of conduct here demonstrates that this is a 99-year proprietary lease or something greater than this month-to-month tenancy we've got, apparently. But it seems like it is month-to-month, and I believe the code says 30 days, so the fact that they're giving them 60 is gracious, and it's unfortunate. It's bad facts, with it being someone who's elderly as well. But I would say they need to, prepare themselves to move. I mean, what they're going to be looking at is some sort of either eviction action or an ejectment is what it's called when there's no lease in place, and it's going to wind up with a lawsuit getting filed, and then with lawsuits you got to file answers and you got to hire attorneys, and it's great.
Right.
It's great for the attorneys, but it's not so great for the client in these situations where the outcome's extremely predictable, in my opinion, Sue.
Okay. I just thought that there was something with the rental industry now where you can't just remove a tenant just because you feel like doing it. But maybe I misunderstood.
No, to that point, you've demonstrated that point this morning. You said they gave them 60 days notice, so it's not like they showed up on their doorstep and said, "Hey, get your stuff." They've given them notice.
Right.
That's what they're entitled to. And like I said, because, and not to speak poorly of the elderly person here, but they failed to protect themselves. They should have protected themselves with a good written lease and insisted upon it and said, look, I want a lease for 5 years with an option to extend or something like that. The lease will protect you. And that's the lesson to everyone listening. You will live and die by the terms on that page. It's the Four Corners Doctrine. And at the end of the day, in general contracts analysis, the words on the page are there to protect you. And they're there to protect you not for when everything's going swell. They're there to protect you for when everything's going poorly. That's why when I draft contracts, I often bring in civil litigators to take a look over my shoulder, because they're the guys who are going to be leaning on this language when things don't go well. And so I want their input now about what language I need to have in these agreements for them to use. What arrows do you want in your quiver? What do you want in your arsenal if things go poorly under this contract? So there's an artistry to this. And it seems like this particular person just either wasn't aware of that option or didn't avail themselves of that option for whatever reason. And maybe it was a health reason, or whatever the case may have been. But the failure to fully avail yourself of the right to have a written lease is what's producing the consequence. So it's not like the landlord here is simply kicking them out. I mean, they are, but they're giving them notice, which is what they're entitled to.
Right, and I understand 60 days is a gracious time frame by law.
Yeah.
I think whoever's listening to this was just a complacency issue. Being considered a part of the family, having gone through this relationship for decades, you get complacent and you trust. And I understand what you're saying. The written contracts are not for the good days or for the bad.
Well, listen, I certainly understand the importance of having things in writing, and I see it every day. I see it day in and day out, Sue, where people fail to protect themselves with things. Now, and to the other side of the coin, I see a lot of situations where people say, thank the Lord that we had this in writing and that we had these protective measures in place. And it's not just with regard to wills and trust. I mean, granted, that happens daily too. I'm so thankful Mom and Dad had all this in writing because it helps things go so smoothly. We don't talk a lot about those cases because they're the easy ones. They're the ones that aren't very exciting. They're pretty mundane and pretty perfunctory. And it's the same with, leases where there is a written lease. The landlord tried to kick them out. They said, no, I've got a right to stay here another 5 years. That case goes away quietly too, so there's nothing to talk about. So we wind up talking about these kinds of cases. But there are a lot of people who do avail themselves appropriately of the laws regarding leases and using those leases to protect themselves. And it's ironic here because it's usually the landlord that's insisting on the lease. The landlords like to use lease, and they usually draft them through their attorney. It's kind of lopsided in the landlord's favor because they want to make sure that they're in that power position. And so if their attorney's drafting it in their best interest. So that's sometimes where you see, especially with commercial leases, you'll see attorneys on both sides sort of negotiating the terms of the commercial lease because they're sort of jockeying for position. And is there going to be a binding arbitration clause in the lease? What's the venue for any dispute going to be? Is it going to be where the landlord's, main operation for corporate operations is in some other state, or is it going to be here in the state of Florida? I mean, all these terms are negotiable. Is there a good attorney's fees clause in it? I mean, so you can see where these things, hours and hours can be poured into them sometimes. That's not so much at the residential level, but at the commercial level. And the reason for that is designed to protect everyone and give them all peace of mind. That's what everybody's looking for, to know that if something goes poorly under this lease, I'm protected.
Okay, well, I think in this situation, to your point, I think the landlords didn't want a written contract because if they decided to sell the property she was in, they would ask her to move to another property, and she was happy to do that. So they were helping both sides. Well, I think didn't want it in writing for that reason.
Yeah, well, knowing what we know now, that appears to be the case. But hindsight being 20/20, Sue. I mean, that's always going to be the option. So, at the end of the day, the short version is for your friend. The next property they move into, they should definitely have a written lease so they know exactly under what terms and conditions they'll be living there.
Okay, very good. I'll let you get on to other people that need your assistance. Thank you, and have a great weekend.
Sue, thank you for calling in. You have a great weekend as well. Okay.
Thank you. Bye-bye.
Yes, ma'am. Bye-bye. All right, you listen to the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith. The number to call in and be part of our show today, 877-943-9673, 877-943-9673. And you can email your question, Patrick, at attorneypatricksmith.com. Again, you can email that question 24/7. We do check them throughout the week, but if you email during the show, we try to answer them on the air, Patrick at attorneypatricksmith.com. Or give us a call now. We have open phone lines. We'll get you and your question right on the air. The show started real fast with a great trust administration question regarding valuation, postmortem valuation, and basis adjustment of assets. How's that for 8:25 on a Saturday morning? And then we went straight into landlord-tenant law regarding evictions and notice requirements and the opportunity to protect yourself with a good written lease agreement. And you can ask the next legal question, 877-943-9673, 877-943-9673. So I was asked to give a shout-out to all of our family of stations out there listening. So if you're listening to us now, you're listening on one of 7 stations. And that's either 90.3 FM, WLVF out of Haines City, 93.7 FM, 96.3 FM, 102.5 FM, AM 570, AM 930, AM 910, and AM 860. Whew. And as of February 5th, we will also have 102.5 The Bone joining our family of stations that carry the show, so it will be up to number 8 on our slow march to 10. That's just been the goal in my mind. There's no particular reason. It's just 10 sounds good, I think. There's anything wrong with 7 or 8. 877-943-9673. That's your live and local number, so give us a call now or email your question, Patrick at attorneypatricksmith.com. All right, let's go to beautiful Clearwater, Florida, and let's talk to Carl. Carl, welcome to the Attorney Patrick Smith Show.
Good morning.
Good morning, Carl.
I certainly appreciate all that you do in your show. We've listened to the previous editions under Attorney Pippin, but we really appreciated what you are doing.
Well, you have no idea what that means to me, Carl. I appreciate your kind words about myself and Mr. Pippin. Thank you very much for that, Carl.
Well, thanks. Say, in an injury situation where there's a work injury, what is the boundary or the responsibility of the employee and of the employer? as far as workman's compensation?
That is a great question, and it's an easy one for me to answer, Carl. I don't know.
Okay.
But there are a couple of fantastic attorneys that I work with who are personal injury and workers' comp attorneys. That is their bailiwick. And I will give out the office number here in just a few moments. Carl, call me at the office on Monday. I'll put you in touch with them free of charge. They will answer that question and get you pointed in the right direction as far as workers' comp or any statute of limitations or deadlines or filing requirements and all the ifs, ands, and buts about that kind of situation.
Excellent. Thanks so much.
Yeah,
have a great weekend.
No problem, Carl. Have a great day. All righty, you're listening to the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith, 877-943-9673, 877-943-9673. And Carl's a good example that, we don't always have the answer to the question, but our promise to you, we will always be able to put you in touch with someone who can get you the very best answer to your question. And we work with kind of a network of professionals, not just attorneys, but financial advisors, CPAs, and other professionals in industry who may be able to help you. So if your question's outside of our bailiwick, again, that's our promise to you. We'll put you in touch with someone who can give you the very best answer. 877-943-9673. That's your number to call in and be part of our show today. 877-943-9673. Or you can email your question, patrick@attorneypatricksmith.com. All right. You guys can't see it because the camera, for those of you watching on Facebook or Instagram, he's up to the microphone. Like when he's pregnant with comment. Like he postures into position. He just did so. So Peter, the intern, I guess you have something you would like to add. Please proceed.
Yeah, I've got a really good email question.
Okay.
They said, I got a ticket on the road by a cop who was sitting off the road without any lights on. Is that legal or is that entrapment?
The cop didn't make you speed. That would be entrapment. I mean, if the cop pulled you over and said, hey, it'd be cool if you drove 100 miles an hour in this 35 and then you did it and then you got pulled over, that's entrapment. The cop doing his job by being on patrol, that's perfectly legal. I don't see any problem with that. I say that to say this, though. We have attorneys we work with who do traffic violations. So if you need help with that, I'll give out the office phone number and we can put you in touch with our attorneys who handle our traffic violations and those sorts of matters. So if you have a particular need with regard to that, we can certainly help. But no, it doesn't sound like entrapment to me. I mean, entrapment by its classic definition is where the law enforcement caused you to engage in the crime. And I simply don't see a cop sitting there. I mean, the question, does he have to have his lights on? I don't think so. I had a client one time that got pulled over in a school zone, and the officer told him something to the effect of, their school zone apparently wasn't marked like with the traditional signs and the flashing lights. Apparently the marking for this school zone was an orange cone, but it wasn't even like a full size orange cone. Like it's like one of the mini orange cones. So like that's the marking that it's in a school zone. And it's like a local thing. You had to know it. And if you didn't know it, then you're up a creek. And so what happened there was a situation with, was that entrapment? And again, that was a closer case, I think, because there, if you don't know it's a school zone, if this little orange cone is supposed to indicate it's a school zone, that's almost an invitation to speed, because the regular posted speed is one thing. Orange cone does not tell me that I need to change my speed to a different speed. So I think that was a closer case to entrapment. I don't know that even got there, but it's closer than the description in that email question. 877-943-9673, 877-943-9673. That's your live and local number to call in and be part of our show today, 877-943, or just like whomever that was, you can email your traffic questions or any other legal questions to Attorney Patrick Smith by emailing it patrick@attorneypatricksmith.com, patrick@attorneypatricksmith.com, or give us a call now, 877-943-9673. I want to talk a little bit more about trust administrations and how those work, kind of parlaying off our first call of the show from Carl. But before I do want to give out that office number. I know I've promised it here a couple of times. So to reach us at the office during the week to schedule your complimentary consultation regarding your estate plan, your will, trust, your probate situation, if you need a referral to workers' compensation attorney, personal injury attorney, if you need a referral to a traffic attorney, we'll be happy to help you. The number to reach us at the office during the week, 877-754-6764. And that's for any of our offices. The office in Sun City Center, where you guys are so loving and warm down there. We cannot thank you enough for the warm reception we get every time we go down there. 877-754-6764 to schedule in Sun City. That would also be the number you would call to schedule here in Seminole as well. So, or for any of our other office locations, 877-754-6764. And any of the office staff will be more than happy to get you scheduled. Or if you just had a quick question and wanted to chat during the week, you can always call and speak to us via telephone during the week as well. So, all right, let's go to Clearwater and let's talk to Marie. Marie, welcome to the Attorney Patrick Smith Show.
Yes, hello.
Hi, Marie. How are you today?
Fine. I just want a general question. How are hospices allowed to murder people by opioid injection?
How? So the question is how are hospitals allowed?
Hospices.
Hospices. Well,
Hospices, and you can't get any type of records. They redact everything.
Well,
how are you allowed to do that?
Well, they're not. Murder's illegal in the state of Florida, to clarify for everyone listening. And Marie, what I hear in your voice, and you don't have to share anything you don't want to share because we're on live radio. I hear trauma in your voice. All right, I hear like you've been hurt by something related to this subject matter. Okay, and I want you to know that I can hear that hurt in your voice, and I'm sorry that you were hurt by that. But it is not legal to murder anyone in the state of Florida. Indeed, euthanasia is not permitted in the state of Florida as well. So it's not. So the premise of your question is faulty. Hospice, in my opinion, does amazing work and does an amazing job providing care for people who are getting ready to enter eternity, and they are not murdering people. And I think that that it's unfortunate that you hold the opinion you do, but I disagree with it with all due respect. But at the same time, I do respect the trauma and the hurt that I can hear in your voice, and I'm very, very sorry that you're hurt.
Yeah.
All right, Marie.
Yeah.
I'll say a special prayer for you, okay? All right. God bless you, Marie. We'll be praying for you. 877-943-9673, 877-943-9673. You can give us a call now. We're live and local and happy to help any way we can. 877-943-9673, or email your question, patrick@attorneypatricksmith.com, patrick@attorneypatricksmith.com. So to start off the show, Carl asked a question about valuating trust assets and what happens when a grantor dies. One of the fantastic questions that came in during the law office this week was someone was in, and their concern, their general concern, like a lot of people, is I want to put together a plan so that there's no fighting when I'm gone. I mean, I'm sure hundreds or thousands of you out there are relating to this and nodding right now saying, yeah, that's what we want, is for there to be no fighting. And they always start with, what am I going to have to do to make sure there's no fighting? And we joke with clients and say things like, make sure the last check bounces or something like that, and then there's no fighting. But at the end of the day, there is a lot you can do, and it's with regard to putting together a good plan. But it led to this follow-up question, and it was a fantastic question. The client said, okay, Patrick, but sitting in that chair and working with the thousands of clients that you do, what are the most common reasons that people challenge wills or trust or whatever? And I thought it was a fantastic approach. And again, it was sort of like we talked about earlier when we were talking about leases. We were talking about leases and how to use them to protect you from lawsuits. And so you look to litigators to give you advice on what happens and how situations develop in lawsuits and what language you want in there. So I thought this approach was fantastic to say, okay, if I'm drafting my will or trust, what are the most common things that would cause a challenge? Well, Believe it or not, one of the most common reasons challenges break out in wills and contests has nothing to do with the money. It comes down to the things, like personal property, mom's diamond earrings, or dad's pipe, or something that's a personal property item. So we have a solution for that. The statute is 732-515. For those of you who like to look up statutes, I know I have listeners out there who love when I give out the statutory references because they love to look them up. The 732-515 separate writing attachment is where you can articulate those bequests. And you can do it sort of en masse and say all contents of the home to this person. You can be very broad like that. Or you can be very specific. This ring to this person. This firearm to this person. Whatever. So you can be as broad or as specific as you choose to be in this particular document. Sign and date it. As long as it's incorporated into a validly executed Florida will, you're in good shape. And you can modify that without having to pay an attorney to modify the will. That's the nice thing about the separate writing attachment. So having a good separate writing attachment goes a long way to address one of these reasons why people challenge wills or trusts. The next thing that came up was in-laws. People said, well, who do the challenges usually come from? Is it one of the kids? And believe it or not, it's usually not one of the kids. It's usually one of the kids' significant others. It's either a spouse of a child or a significant other of a child. And so I recommend in situations like that you make sure you draft accordingly so that the in-laws really aren't involved in the plan. I mean, unless you have a particular affinity for your in-laws, you can craft a plan that keeps everything straight bloodline. And then the other thing you can do is when it comes to selecting an administrator, someone to operate that. In our first caller, Carl's question about being a trustee, I mentioned that I serve as trustee for clients. I do. And a lot of those situations where I'm serving are to have a neutral trustee so that none of the family feels like, oh, mom or dad picked A over B. Or if it's a blended family scenario where the two families may not know each other so well, they have a neutral party. And it can be any neutral party. It could be a family friend. It could be another family member who's not a beneficiary. But someone to serve as a neutral trustee goes a long way in neutralizing particular contests, because that is one of the sources of angst from the in-laws, is that someone got picked to be the administrator. They view it as this prize or trophy that they were picked somehow ahead of everyone else, and it's not that. It's an administrative role. And yeah, it usually carries a small compensation for it. We call it under the trust code a reasonable fee. But at the end of the day, it's for doing a lot of work, marshaling assets, paying creditors, preparing and filing a tax return, preparing an accounting, answering countless questions. Just the marshaling of assets alone takes countless hours on many estates. So having that designation is not a position of honor so much as it is being an animal or something. You're just going to be the burden bearer. You're going to be an animal of labor, so to speak, at that point. Beast of burden. That's what I was trying to find. Thank you. So you're going to be bearing a lot of weight in that position. So a lot of times people choose a neutral party to remove that tension. The other reasons we see people challenge undue influence, they believe that someone was involved. That's why when people call and you see someone come bebopping in with a relative and saying how that relative's will ought to be, you have to send them out, and you can't do that. You can't do a will for a person. I've seen that scenario recently where someone's trying to do a will for another person. Yeah, believe it or not, they have to do their own will. And then you see a lack of capacity is another basis for a challenge, where someone doesn't have all their faculties. So I think that's the lesson there is to do your will sooner as opposed to later while you're younger and healthy and of sound mind. You don't want to have the will done in close proximity to some doctor diagnosing you with dementia or Alzheimer's. I think that could potentially weaken the integrity of the document. So you want to make sure that, I think the lesson there, doing it earlier as opposed to later, strengthens the document. So it was a fantastic question from a client regarding, well, if the challenges are going to come, from where are they coming and how do we address it? And so I really think that was a great way to approach it. We, as a scrivener, we approach it from the other side of the drafting approach and not so much the concern about a challenge but it was sort of a great way to dovetail the two concerns and really produce an ironclad document for that particular client. So maybe you have a question about your documents or some other legal matter. You can call in now, 877-943-9673, 877-943-9673. We have open phone lines. We'll get you and your question right on the air, 877-943-9673, or email your question, patrick@attorneypatricksmith.com. Patrick@attorneypatricksmith.com. And as all of you know, we are available for speaking engagements. If you have a club, group, organization that could take advantage of hearing one of our presentations, you're all aware of the presentations we're doing on homestead. We also do presentations on a wide variety of other topics. Indeed, we customize them for groups when requested. And if you'd like to set one of those up, you can give us a call at the office during the week, 877-754-6764. And you can email us, patrick@attorneypatricksmith.com. But speaking of speaking engagements, we have 2 coming up this week. I'm going to throw it to Peter, the intern, so he can give out the details. Peter.
So the first one this week is on Wednesday, January 26th, and it is at the First Baptist Church of Indian Rocks over in Largo, Florida. Patrick is doing a little speaking engagement on wills, trusts, and probate. It's going to be in the Smiley's building or the College Group building. And then the very next day, on Thursday, January 27th, in Groveland, Florida, at the Woodlands at Church Lake, Attorney Smith is doing another one on wills, trusts, estates, and probate.
All right, so 2 back-to-back nights. So come out if you're in the Groveland. For those of you not familiar, that's the Lake County area, sort of South Sumter County. If you're in Groveland, Claremont, Winter Garden, Mascot, Fruitland Park, that area surrounding the villages, you can pop on down to the Woodlands at Church Lake on Thursday night. Or if you're in the Indian Rocks area, Seminole, Largo, that area, we will be presenting at Indian Rocks Baptist. I've never called it the First Baptist Church of Indian Rocks Beach in the 30-plus years that I've been going there, and never called it that. I've always called it Indian Rocks Baptist. Is that a thing?
So it was First Baptist, and I'm just used to calling it that. Now they actually changed the name to just Indian Rocks Baptist Church.
When did it change?
A couple years ago, a year ago.
Does Pastor Charlie know about this?
I don't know, probably not.
Okay, all right.
Uh-oh.
Okay. I had no idea. I had no idea. I've been calling it the wrong thing. Or I've been calling it the right thing, but I've been calling it the right thing accidentally because it was the other thing.
It was First Baptist for however long.
Okay.
First 40 years of its existence.
The church in Indian Rocks Beach. There we go. We're safe. So we'll be there Wednesday night if you want to come out and hear us speak. You said 6:30 is Wednesday night?
Mm-hmm.
And then Thursday night, Woodlands at Church Lake is 6 p.m. So feel free to come out. To RSVP or to get more details for either of those events, you can always call the office directly. The office staff has all the information on my speaking engagements. It can help you with directions, addresses, or any of that sort of good information. So feel free to give the office a call. 877-754-6764. 877-754-6764. Still plenty of time for your question. Give us a call now for today's show. 877-943-9673. 877-943-9673. Or email patrick@attorneypatricksmith.com. All right, let's go to beautiful Sarasota, Florida, and let's talk to Jim. Jim, welcome to the Attorney Patrick Smith Show.
Hi.
Hey,
I
Jim.
got a question about why can't you put an IRA in your trust?
You can, Jim.
You can? How does it work?
Well, the reason why you typically don't want to put an IRA in a trust is because of the tax consequences associated with that. So who's your don't say the name. Do you have a financial advisor, Jim?
I'm it.
You are it. Now, are you a licensed financial advisor or are you a lay financial advisor?
I'm a lay.
Are you also your own attorney, Jim? I just want to understand what I'm working with here.
Pretty much.
Do you do your own surgeries, Jim? How far do we push the self-sufficiency, Jim?
No, I don't do my own surgery.
Good. We found the line. So there is a line. Good, Jim. That's healthy. And at the end of the day, I think it's worth a conversation with a financial advisor. I work with tons of them. All of them will be happy to speak to you free of charge. They're appropriately licensed to talk to you about the options and advantages and disadvantages. But from the legal perspective, number one, we're not so worried about IRA accounts because they don't go through probate if you have an appropriate beneficiary designation on there. And
well, the whole purpose of a trust is to avoid probate. That's the reason for the question.
Well, and that's what I'm saying. So typically, you set up the trust for all the non-qualifieds, or in your terms, the non-IRA stuff. So if you have a home or standard brokerage accounts, checking, savings accounts, those are the accounts that typically get funded into the trust. Now, I say that to say this, Jim. In certain situations, we do route qualified accounts through a trust, but it's typically where there's a minor involved, someone who can't receive the money directly anyway, or a situation where someone's special needs and when they're receiving state aid or government assistance, something to that effect. And we have to make sure that when we do that, we put accommodating language in the trust for those particular qualified accounts. And we also typically coordinate with the custodian, the party that holds and manages that IRA, to make certain that that language we've added will be effective with them when the time comes. So you can route it through the trust. It's just typically something done under a couple of exceptions and requires a few additional steps. But it can be done, Jim. But it really should be a conversation between your licensed attorney of your choosing and your licensed financial advisor of your choosing. There's a synergy there that's going to lead to an optimization that's going to keep you and your family most protected.
Okay, so if you want to do it, just put the language in the trust to do it, basically.
If you hear nothing else today, Jim, here Patrick said I need to sit down with an attorney and a financial advisor and sit down with them and have a complimentary consultation about what am I going to do with these IRAs and why am I doing it that way. At least that way you'll know why you're doing it. If you're directly beneficiaring them to particular people, or if you're somehow involving the trust, you'll know what you're doing before you do it and why you're doing it. Does that make sense, Jim?
That makes sense, yes.
Good.
Thank you very much.
Jim, you're most welcome. Enjoy your Saturday in Sarasota, okay?
Thank you.
Yes, sir.
Bye-bye.
Bye-bye. All right, you're listening to the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith, 877-943-9673, 877-943-9673. We're live and local, happy to help any way that we can. You can always email your question, patrick@attorneypatricksmith.com, patrick@attorneypatricksmith.com. And Peter, you know what? We've got a couple minutes. Let's do fan mail. So Peter liked the fact that we did the fan mail segment last week. So yesterday was his birthday. So happy 22nd, 3rd, 23rd. Happy 23rd birthday. We're going to let Peter do his fan mail segment he wanted to do. Peter, the floor is yours.
So the first one is, why is Peter the intern never on camera?
Well, it's never been an active decision to keep Peter the intern off camera, but I will tell you, from my early days in radio, even when I was an intern, there was what we call a dress code, and Peter the intern does not necessarily follow any dress code. I don't have a problem putting Peter. I just think we need to get the extra camera. If I were to, and I mean this with no disrespect, if I were to describe Peter the intern's look, it kind of looks like he's getting ready to go to an audition to be the fourth Beastie Boy. That's sort of his dress style. And I like the Beastie Boys, but I say that to say this, like, it's a very relaxed attire. For those of you watching me, you can see I'm wearing a collared shirt, button down. Peter is very relaxed. So, but we could put a camera on Peter. I don't think that would be a problem. Go ahead, Peter. What's the next one?
Another one was, so thankful to hear Yana is continuing to read email questions and ask Attorney Patrick Smith questions for the show.
And we didn't have Yana read one today, and I told Yana, I said, so we have a minute. Yana, do you have any legal question? You have a legal question? Do you have? Yana's shaking her head. No, she's like, she was not prepared for this. She was not. But I told Yana, I said, there's going to be people out there that are going to really enjoy hearing you read the legal questions. So go ahead, next one.
The next one is, it's a lot of the same ones from last week. was we are so thankful for Attorney Patrick Smith and all that he does and helping us with our legal needs for free on the air.
Well, I appreciate that. Thanks, guys. And I get your emails and your prayers that you email over and all your support. I really appreciate it. It means the world to me, all your support. I feel it, and I thank you for it, and it'll keep us coming back so that we can help you every Saturday. So be back with us next Saturday. We'll be back with you 8 a.m., bright and early, Saturday morning, to answer your legal questions on the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith. To reach me during the week at my law office, 877-754-6764, or email me, Patrick at attorneypatricksmith.com. Everyone stay safe. God bless. Have a wonderful Saturday.